Hey guys, come on in, have a seat. In the divorce case of Kandi Burruss and Todd Tucker, Todd is asking the judge to deny Candy's request to seal the divorce, explaining that Georgia law treats court records as public. Sealing is rare, and claims of embarrassment or privacy aren't enough, especially when Kandi has already spoken about the case publicly. He argues the court should not let confidentiality be used to control the narrative instead of protecting real safety concerns. Let's get into the court document, shall we?
Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah.
All right, y'all already know about my QR code, direct link to the X, and my copyright disclaimer. Now, let's go right on ahead and get right into the actual court document. So, husband's response in objection to petitioner's motion for confidentiality order and motion to seal in brief in support thereof comes now respondent T. Jermaine Tucker by and through his counsel of record. And as y'all can see, that is the names of his counsel, and files this his response in objection to petitioner's motion for confidentiality order and motion to seal in brief in support thereof, and respectfully showing this court that petitioner, while having filed a motion for confidentiality and to seal seeking extraordinary relief, petitioner has incessantly discussed the instant divorce with various media outlets, including print, televised, and online platforms, while husband has refrained from any public commentary regarding this matter, and further showing this court as follows. First defense, petitioner K. Lennis Tucker fails to state a claim upon which relief can be granted pursuant to OCGA 91112B6. Second defense, petitioner fails to allege any appropriate basis for sealing the record pursuant to Uniform Superior Court Rule 21. Enumerated response. In response to the specifically enumerated paragraphs in petitioner's motion for confidentiality order and motion to seal, husband shows the following. And as y'all can see here, it's a few bullet points. So let's go ahead and get started with that. So bullet point number 1, husband admits the allegations contained in paragraph 1 of the motion. Paragraph 2 of the motion does not require a response from husband as it contains petitioner's prayers for relief. To the extent that a response is required, husband states that while he recognizes the importance of protecting the minor children and is not averse to redacting the home address of the parties' addresses are a matter of public record and may be found by looking at the recorded deeds filed with the Fulton County Clerk of Superior Court, as well as via the Georgia Superior Court Clerk's Cooperative Authority. Furthermore, the parties' financial disclosures have no effect on the best interests of the minor children and are not filed in the court record in any event. Rather, only a certificate reflecting that such disclosures have been exchanged is filed, which does not contain confidential financial details. The relief requested by petitioner is overbroad and unsupported by law to the extent it seeks to render categories of information confidential or restrict public access to the record, not out of concern for physical safety or best interests of the children, but to solely protect petitioner's interests. 3. Paragraph 3 of the motion does not require a response from husband as it contains petitioner's prayers for relief. To the extent that a response is required, husband states that petitioner prayers for relief should be denied in their entirety. By the way, let me y'all give me 1 second. All right, had a burp. Ooh, all right. So, by way of further response, petitioner's assertion is contradicted by her own conduct. Since the date she filed for divorce, petitioner has engaged in a public press tour, including making statements directly and through her agents to multiple media outlets, and has continued to publicize the existence and substance of this litigation on social media and in the press. Having voluntarily placed the proceedings into the public domain, petitioner cannot now credibly claim that sealing the case is necessary to protect the integrity of the proceedings or the best interests of the minor children. Rather, the requested relief appears aimed at selectively restricting public access in order to control the narrative of a dispute that petitioner herself has chosen to make public. The court should not permit confidentiality to be used as a strategic tool to manage public perception, particularly where less restrictive measures, such as targeted redaction, are available in sufficient. Paragraph 4 of the motion does not require a response from husband as it contains petitioner prayers for relief. To the extent that a response is required, husband states that petitioner's prayers for relief should be denied in their entirety. Paragraph 5 of the motion does not require a response from husband as it contains petitioner's prayers for relief. To the extent that a response is required, husband states that petitioner's prayers for relief should be denied in their entirety. Additionally, husband shows that petitioner fails to demonstrate why the record in this case, unlike the record in other divorce cases in Georgia, should be sealed, or petitioner's motion for confidentiality order and motion to seal should be granted. In further response, husband shows that the only substantial filings in the case are a complaint for divorce, answer and counterclaim for divorce, amended petition for divorce, answer and counterclaim to amend petition for divorce, petitioner's motion for confidentiality order and motion to seal, and the instant response and objection to petitioner's motion for confidentiality order and motion to seal. Moreover, petitioner fails to present any factual basis demonstrating how the purported need for privacy in this case differs from the thousands of other domestic cases filed in which similar information is a matter of public record. To husband, it seems that petitioner, without basis or justification, seeks to use the party's status as public figures to secure benefits not routinely afforded to other litigants or the general public. Paragraph 6 of the motion does not require a response from husband as it contains petitioner prayers for relief. To the extent that a response is required, husband states that petitioner prayers for relief should be denied in its entirety. So it looks like that's a repeat in some of these. And on this y'all see number 7, it's a repeat. Number 8, any allegations specifically admitted to herein are denied. And then here goes the argument in citation to authority. And as y'all can see there is case law. So pause your screen. Y'all can read this, but we're going to scroll on through because it looked like we're right here at the bottom. And we are. So as y'all can see there, the husband respectfully requests that petitioner's motion for confidentiality order and motion to seal be denied in its entirety with all costs cast against petitioner, that husband be awarded such other and further relief as this court deems just and equitable. And we are at the bottom, y'all. Ooh, so it looked like things are heating up. What do y'all think about Todd's response here to the objection to Kandi trying to seal this case? Y'all leave y'all comments in the description box below. And as y'all already know, I appreciate y'all so much. Thank y'all for subscribing. And if you like what you see here today, like, share, and subscribe. And as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, I'll see y'all on the next video. Peace.
Candy girl, keep your